Shalom, shalom, shalom. This is your Ark. Yah is magnified, and I'm back with another informative video. I titled this video, Contact Letter About Case Closure. But before I tackle this subject, as always, I must state for the record, I'm not a lawyer, I do not practice law, and I do not pretend to. All my videos are for informational and educational purposes only. They're all facts and all truth, nothing more, nothing less. So with that being said, guys, let's get to it. Okay, so now as you all know, for those who've been following me, you know, my number one issue that I tell you all to do, and my main thing that I tell you all to do when I come on YouTube is to do what? Stop running from these people and face them head on, okay? So now, as you all can see on the screen, this is what? A contact letter about case closure. Alright? So, when I come on here and tell you guys to do something, I just don't tell you all to do it without showing evidence that you get remedy that way. Okay? I just don't come on here regurgitating definitions all day without showing evidence of anything working. Okay? I come on here, show y'all proof, keep it moving. Why? Because the proof is what people need to see. That's it. That's all. Anybody can tell you anything. Okay? Like for instance, you have individuals on YouTube teaching you all to send the mail back. But to make it even worse, that individual say send the mail back and attach a return receipt to it. For those who do not know what a return receipt is, a return receipt is a green card that you receive from the post office. That green card, you put the person name who it's going to on the front, and on the back of the green card, you put the address where you want the green card to be returned to. Okay? Once that letter gets to the person who is addressed to, that person will sign the green card. The post office guy will take the green card, mail that green card back to the person that sent the mail. Okay? So, you have an individual telling you all to do that. So, he wants you to take that mail, put a green card on it, mail it back. They will sign for that mail back, get the green card, send it back to you, and that's proof that you mailed the green card back, right? I'm going to show you all and tell you all how stupid that sounds. It sounds so stupid because it makes no sense. Alright? For one, once they sign that green card, they know that someone else or someone put that green card on there. So it means it was received by someone. So the agency will simply tell the judge that it was received. As you can see on the back of the envelope, it had, it shows that it was actually sent back to us and it has a green card attached. So someone did receive it. So the judge is going to say, okay, well, we're going to take that as proper notice. The judge is going to say, okay, is that person not here today? They're going to say no. They're going to say, okay, well, we're going to proceed forward with a default order. Okay? Or if the judge said we will not proceed forward as a default order, the agency will simply do this thing that I made a video about yesterday called alternative service. In that video, I showed you all that me and one of my ARCs that I'm working with, we followed rules and procedures, and we also did the same process called alternative service. Meaning that if a person is ducking service, you can just simply place a copy of the summons on the last place of address where they resided at, or they know to reside at. If they do not show up at that hearing, then the court will move and proceed forward. Okay? Once the court proceeds forward and that person do not show up, then default will be granted, or whatever that other person has requested will be granted in that person's favor. Why? Simply because the other party did not show up. They will do you guys the same way. Like I tell you all, the playing field is even on both sides. So if someone is telling you all to send the mail back, do not listen, okay? Especially if that person haven't showed no evidence of him getting himself off of support or showed any evidence of giving anyone else off of child support, okay? If that person don't have no one coming on this channel vouching that his services got them off of child support with evidence, then that person is considered to be a liar and a fraud, okay? And it's just that simple. He know he a fraud, I know he a fraud, and everybody that he dealt with know he a fraud. Because that's why nobody can come on and say, yeah, he helped me out. This the remedy he gave me, and this the results that I got from that guy for his assistance. No, nobody will ever say that. And nobody can never say that because the services just simply don't work. And it's just that simple, guys. But I digress. So let's continue. But once they enter that default judgment order in against you, they're going to start doing what? Garnishing your wages. After they garnish your wages, first thing you're going to do is what? Go back to that person who told you to send the mail back. You're going to say, man, You told me to send a mail back. I've been sending the mail back. They put a default order in against me. That person's not going to have a clue what to do next. Once you get that default judgment against you, they're going to start garnishing your wages, taking all your money and everything else. Forcing you to do what? Come back to court. Your argument when you get back to court when dealing with that person is what? He never received the mail. He sent it back. The proof of him sending it back is the green card, right? If he showed proof of that green card in court, that proved that he actually received it and he chose on his own to send it back. So if he showed that green card, that's proof of evidence that he did receive it. And it's also proof of evidence that he what? Mailed it back. So that did what? He waived his duty to speak. Okay, once you waive your duty to speak, then you do what? Tacit acquiesce. And it's just that simple, and you will be on support because you will not have no defense besides that when you get into these courts. Why? Because the person who's telling you how to do that nonsense do not have a clue of what he's talking about. And it's just that simple, guys. That's why I'm showing you evidence right now of what a response back to them will get you. Just simply respond back. Stop running from these people. Okay? So now, let's read the letter on the screen so we can get better understanding of what's going on. This letter is, in fact, a what? A contact letter about case closure. True. It's on the screen. All right. This was sent from the New York State Child Support Processing Center, right? In Albany, New York. The date of this letter is July 18th, 2020. My aunt just received this letter about 2 days ago. He sent it to me in an email. It's crazy that he received this 2 days ago and he sent it to me in an email when I wanted to have to prove this information to you guys. Further letting you all know that the Most High is moving and he will put you all on the right path if you just simply pay attention. Okay? So now, this is dated July 18th, 2020. All right? Almost 3 months ago. Let's continue forward. New York case identifier, I crossed the case number out. Custodial parent name, I crossed her first name out, kept her last name. The non-custodial parent name, I kept his last name and also kept Junior, so you can see the difference between the male and the female. Why? Because they was in fact married, so she took on his last name. Okay? County name, New York City, and again, contact letter about case closure. All right? Let's see who this letter was sent to. This letter was sent to Miss Richardson, because you don't see the Junior in the back, so it clearly was sent to his child's mom. Okay? His child's mom took a picture of this letter and sent it to him. Why? Because she's trying to find out what the hell is going on. What's going on is she gave them his so-called address, and she also know that she is receiving services. But she also know that it's not coming from him, and he's not paying them a dime. Okay? Why? Because they told her that they're about to close the case. Let's continue forward. Again, remember the date. July 18th, 2020. Remember this date. And like I told you, my aunt just received this letter from his child's mom. So she know what had happened, and he know what had happened. But let's continue on. It states, please read the following information and contact us immediately. Sending this to his child's mom, telling her to contact them immediately. Why? Because things are not going as they planned. This gentleman that they dealing with is sort of different. This gentleman actually responded back. This gentleman did not send the mail back. This gentleman faced them head on. This gentleman is not running and tucking his tail in his legs like a coward. That's the difference between the people who know the truth and the people who pretend so. Let's continue forward. It states, our records indicate that you are in receipt of child support services from us. So that means what? The child mom is in receipt of services from them, so they are giving her services. Let's continue. However, we have been unable to contact you and are unable to take the next steps in child support case because we need information you may have, or we need you to cooperate with our efforts. Right? Let's read the common reasons. Common reasons why we are unable to take the next step in your child support case includes the first one. We do not have your most recent address and telephone number on record. But we know they have her most recent address and telephone number on record because they just sent it to her. As you can see, that's her fingers right there on the document when she sent it to him. Okay, so we know that part don't apply. Let's continue. We need basic information concerning the non-custodial parent / punitive father, such as full name, social security number, or current mailing, residential, or business address. But we know they have that because we simply responded back to the documents. Okay? I also showed you all a video of this guy who they was trying to railroad, the same person, Mr. Richardson, with a dismissal. Let's continue. Let's continue. Simply responding back. Let's continue. Okay, so I just want to show you all that they in fact have his personal information, social security number, and everything else. Okay? Why? Because we've been fighting since October of last year. So it's been a whole year now, and they still haven't moved forward, and they got to the point now where they're telling this child's mom that they're going to stop giving her services. But let's continue. It states right here. Boom. Right? It says, at a term of family court of the state of New York, is in what? County of Queens, and the date was December 18th, 2019. Just to show you all this simple fact, right? Now we have, at the top, in the matter of a support proceeding, so we know it's just dealing with support, file number, docket number, CSMS number I've crossed out, and this is what? An order on the motion. But let's see who the parties are. The parties is what? Miss Richardson, who is in fact the petitioner, right? I crossed her social security number out, so they have her social security number. And Mr. Richardson Jr., his social security number, and I crossed his social security number out. So you know what? They have his social security number too. So there is no excuse. Okay? They have his address, social security number, and everything else, and we're going to further prove that. Why? Because it's his motion and he moved the court. But let's continue. And this is the respondent. Okay? So my ARC is the respondent. C is the petitioner. But let's continue. Let's read it. A motion having been filed with this court on October 4th, 2019, requesting an order on a or an objection to jurisdiction and a support magistrate of this court upon examining the motion papers and supporting affidavits and hearing testimony in relation thereto, and the following having appeared. So they both appeared. Let's read it. Let's hear the court say it. And the following having appeared, Mrs. Richardson and Mr. Richardson Jr. find that the motion is moot, and it is therefore ordered that the motion of who? Mr. Richardson Jr. is moot because the underlying petition was withdrawn with prejudice. So who withdrawn the petition? The petitioner. Why? Because he filed what? Objections to jurisdiction with what? Supporting affidavits. Okay? Killing them softly, man. That's why I tell you all to respond back. So now you see why she's receiving letters stating that we're going to stop providing services. Why? Because they can't move forward. He challenged everything. That's why they mooted his objection. And they forced her to basically withdraw her petition. But let's continue. Specific written objection to this order may be filed with this court within 30 days of the date of the order was received in court or by personal service, or if the order was received by mail within 35 days of the mailing of the order. Okay? With the date January 10th, 2020, right? Filed February 10th, 2020 with the magistrate's signature on it, with the clerk of court signature on it as well. Okay? Further proof to you guys that simply respond back. They have all his information. They know everything about him. That's why the child mom sent them a document, probably like, man, what the hell is going on, man? Why they saying they don't know where you at when I gave them all the information? You actually was in court. You know what's going on. They know what's going on, but now they say they can't find you and they don't know where you at, or they need more information about you when you gave them everything. So now, that's just more evidence that they have his information, they have his social security number, they have everything. You know, they mooted his motion, challenging jurisdiction, because they knew that what he was saying and the affidavit he was providing was crushing them and killing them slowly, so they withdrew the petition. Okay? And now they're withdrawing what? Case closure, and they're closing the child support case. Why? Because it's been longer than 60 days. But let's continue. Let's get back on topic. Let's go there. Accurate names, social security numbers, and address are essential for effective computerized searches of various records. Addresses are also essential to give notice and or serve court papers. Serve as a process for actions we may need to take in court. Okay? But then again, they have this man's information. Why? Because we've been fighting them and we've been winning, as you can see. So they just telling her anything, and she sent it to him saying, well, they're saying that I gave them the wrong information. But in fact, you gave them the right information. You know you gave them the right information. But because we've responded back, they're telling you that we don't have his information. Oh, what a tangle where we weave when we know what we're doing. But let's continue. Please contact us immediately to provide the information necessary for your child support case. You may contact us in writing at the address shown above or by telephone, toll free at the number, Monday through Friday from 8 a.m. to 7 p.m., A listing of recognized relay services, service providers, excuse me, guys, can be found at with the government agency, right? Then it states, if we do not hear from you within what? 60 days of the date of this letter, we will assume you do not wish or need to have child support services, and we have taken action to close your child support case. What? Support collection unit. So now they told her she had 60 days to close the case. She just sent it to him 2 days ago. The letter was done on July 2018. So guess what? 60 days has been long gone. All right? She do not receive services. She could not receive services. Why? Because he know how to respond and he know who he is. Once you know who you are, then you won't be afraid to respond back. You'll be ready to face these people head on. Okay? It's only people who are terrified, who don't know no better, who haven't had any work or haven't done any work, will tell you guys to send the mail back. Those people I call cowards, man. Face these people head on. And it's just that simple. So, again, don't send the mail back. Address the issue. Seek your remedy. Alright? So with that being said, that's all I'm going to do for today. If you all need my help, hit me up in my email at y'allismagnified@gmail.com. So again, with that being said, I say shalom.